Hello, folks. It's the Bradley J. Show, and we have the triumphant return of Dean Michael Coyne from the Massachusetts School of Law, my favorite school of law. Hello, Dean Coyne.
Hello, Bradley. How are you?
We like to have Dean Coyne on from time to time to talk about current legal activities and events. And today we'll cover the Charlie Baker's son DUI plea, an affirmative action decision we're looking for from the Supreme Court. A woman who was denied the right to wear something she wanted at her graduation, and the blockbuster Trump tape. So let's start with the Baker plea, the Baker plea deal. Tell me about the deal. Tell me about the circumstances, and tell me if the deal is normal or is this some sort of special treatment.
No, it's not special treatment. The former governor's son was arrested for driving under the influence. I thought it was appropriate to add it to our list of discussion points today because it is the start of summer, and I think a lot of people think that this isn't that serious and wouldn't be affected, in essence, by having a couple extra drinks. Well, the former governor's son, was in fact arrested for driving under the influence. And he ultimately, just this week, struck a plea deal on that. And the plea deal really is a very routine for a first offender, as some people are complaining that the governor's son gets special treatment. And the answer is really no, that 90% of the cases for DUI, there's a loss of license for between 45 and 90 days. And also a drug alcohol education program, some fines that are not insignificant. Between the costs of programs and the fines, you're oftentimes looking at $1,000. And if you're going to pay an attorney, which it's wise to do so, those fees can end up in the multiple thousands of dollars. So driving under the influence has serious consequences. The governor's son was able, as a first-time offender, to not face such serious consequences as others, because you can, in fact, be jailed for up to 2.5 years, even on a first offense, and that assumes no one was seriously injured and in the while driving under the influence. So it's a very serious offense, and especially with summertime coming up, I think it's important that people remember that those penalties escalate for each offense. If you're a first offender, like the governor's son, you would be eligible for the program that allows you to escape incarceration, but it still has significant consequences with respect to the loss of license and the fines. And then each subsequent offense, the penalties ratchet up significantly, including even for a second offense, you may very well end up being incarcerated as a result of that. And those are lifetime offenses at this point now. They don't re-energize and go away after a certain period of time. So you've got to be very careful. And obviously, the key to all of this and avoiding all of these problems is simply don't drink and drive without subjecting yourself to this type of peril. And by all accounts, the governor's son, his driving was very erratic. His ability to operate safely was impaired. There were witnesses to that effect. And that's really what you need in order to be convicted of driving under the influence of alcohol. A lot of people call it driving drunk. You don't necessarily have to be driving drunk. What you have to be is driving while your ability to operate safely has been impaired. And that actually is a lot less alcohol than most people think.
Do you think that the level of punishment for first offense is high enough? Does it say, we tell you it's drinking and driving is bad, but we kind of expect that it's a common thing? It doesn't seem that serious to me.
I hear that as I was recounting what the governor's son was able to plead to. It doesn't sound like that's such a significant punishment and deterrent that most people would say, "Oh my God, I just simply can't have a drink." The problem with it is that, again, as you start to think about it, this is a first offense. And shouldn't we try to rehabilitate, educate the person about the dangers, have them now recognize that this is much more serious, and the consequences are much more serious if, in fact, you violate the law again. And I think that's why most cases are disposed of in the fashion that the governor's son was. But people should recognize that the penalties are significantly more severe than what that first offense plea deal is likely to be. For a second and third offense, you're likely looking at incarceration. And if someone was seriously hurt while you were driving under the influence, even for a first offender, you're looking at a period of incarceration likely of 2.5 years because of the serious bodily injury that the person suffered as a result of your being impaired. So it's not uniform that the penalties are as light as that plea arrangement. And in fact, if there are more consequences to your driving under the influence, then even as a first offender, you are likely then to be incarcerated.
All right, next up, in front of the Supreme Court, an affirmative action case, and it could have wide-ranging effects. It could affect not only school admissions, but hiring practices when it comes to diversity. Can you talk about that case and be more specific about the ramifications?
Well, it's a very interesting case that, what is this, June 1? Very, very shortly, we will have a decision on the affirmative action policies of Harvard and the University of North Carolina that are being challenged on the basis of their affirmative action policies towards minority applicants. And most people expect, far more knowledgeable constitutional law scholars than I, expect that the Supreme Court, with the conservative majority now in place, will likely strike down affirmative action, if not scale it back significantly. And then the question becomes, if in fact they do what's expected by most informed scholars, what does that mean for the workplace? What does that mean for efforts at diversity, equity, and inclusion? Some have gone so far as to say that will mean the end of all of these programs in a multi-billion-dollar industry now as well. And that's what'll be interesting. Part of that will be determined by the language the court actually uses in its decision as to how broadly they will either remove affirmative action, not just from colleges and universities, not just in the education setting, but in businesses as well. Certainly, if in fact they choose to eliminate affirmative action policies on colleges and universities and in the education field, some will use the language to say, well, how can it possibly apply to businesses and other entities? But there may very well be language in there that would support that to a much greater extent. But again, until we see the language used, and to some extent we're speculating because they may leave it in place. I think, though, the money is on that they won't. And the question is, how far will they go in striking it down? Will this really affect how businesses operate and how other enterprises try to promote a more diversified workforce?
Well, you're the dean of an institution of higher education. How does it affect you?
Well, it doesn't really, because we have never used affirmative action policies here specifically geared to any minority group. We've always believed that education should be available to all. It should be affordable if you want to have a diverse student body and lawyers that serve their communities. So we treat everyone equally. We look for background rich in experience in helping others, in overcoming significant obstacles. We keep our tuition incredibly low. We're the lowest law school tuition in all of New England, even over the publicly supported law schools. And the fact is, if you want greater diversity, then you need to make sure that the cost is low enough so that all people have access. The other thing we've done from day one is we've never used a standardized test like the LSAT or your SATs for admission to law school. Those tests do have discriminatory results with respect to students of color. If you look at the data, there is no doubt that they are in a disadvantaged position with respect to those scores. If you use them, you then need to offset your other admission standards. We don't use standardized tests. We look at the whole applicant. We try to look at the background. We look at your education, both undergrad and graduate, before getting to law school. And we apply the same standards equally. And then once you're here, we're like the great football coach. We treat everyone equally. We treat you like dogs.
Okay, next up. In U.S. District Court for District of Colorado, Naomi Pena Villasano was told by the principal of her school she could not wear a sash, or serape. They call it a sash, but it's a serape made by one of her relatives that celebrates both her Americanness and her Mexicanness. It's got kind of a Mexican flag on one side, and American iconography on the other. Said you couldn't wear that. She sued. She lost. But what are your thoughts on the reasons school principal might say you can't wear that? And what are your thoughts on those reasons?
And she's lost for now, but there's always an appeal. So even if it's moot at this point, because she
did it anyway.
She did it anyway, and she's graduated, so it's not going to happen again at that school. I'm first going to answer it from with my educator's hat on as the leader of an institution. Our graduation is tomorrow night. We have the Attorney General from Minnesota coming to give our graduation remarks. He's Keith Ellison. He oversaw the murder prosecution where George Floyd was killed 3 years ago. And he's a terrific activist for equal justice, as we say. And here's the problem with this request from an educator's standpoint. So what happens when the next student wants to wear something else? Or another student wants to take an even more controversial position, and they want to wear a Klansman's hood or other insignia that would incite others potentially to violence and the like. You have to have a line, and so it's a slippery slope from an educator's standpoint when you say, yes, we're going to favor some speech and disfavor others. And that's where the controversy comes in. From the standpoint of a lawyer, the courts have oftentimes looked at what schools can and can't do with respect to free speech, be it what T-shirts you can wear in the middle school, or what type of speech you can display publicly, your privacy in your school lockers and the like. And for the most part, the court has always weighed in and said that the schools should be allowed to set their policies within reason, obviously, and that the courts oftentimes should defer to the people who are most knowledgeable about student affairs, being the schools and those that are in charge of it. So it's not a surprising decision to me that the court would, in fact, support the school system. And I do favor that the line has to be drawn somewhere, and you've got to decide what it is you're going to, where that line is going to be. With that said, we have students, we have graduates where their insignia from various parts of their life experience all the time, and we don't object to it as long as it doesn't overwhelm what the graduation is about, which is the graduation from law school for a whole community. And so sometimes students will wear a ribbon or some type of bow or some other type of thing, insignia signifying their heritage or things like that. We don't find that objectionable, and I don't think it should be objectionable. But I also do believe that each school should be able to set some policy limits on what you can and can't do at a public event like that where the celebration is for the graduates.
I guess it all worked out for the best, because you do have to have a policy that says you can't, just in case you need to enforce that policy. But in her case, she went and did it anyway. Maybe they did it. Maybe they told her on the side, "Hey, go ahead. We don't care on this one. You need a policy there in case you need to use it." But in her case, you let it slide. That's probably the best result.
Probably, because just think of the alternative. Okay, so now we're going to drag her out of line. Then there has to be media there. It could potentially be a disaster. So
Right.
Discretion is the better part of valor there, and I think they both probably made the right decision along the way for what was for them personally an important decision.
Next up, Trump asks hush money judge to step aside.
Yeah, it's what's interesting about requesting recusal of a judge because that they have a bias. Is that oftentimes that's first directed to the judge themselves. So the judge who is biased has to potentially make a determination whether they think that such bias exists that would prevent them from being a fair and impartial justice. It oftentimes isn't successful as a ploy to get someone to sort of step aside so you can get a better selection as a judge. And in order to demonstrate the bias, it can't be something sort of generalized like this, that, you've contributed to Democratic candidates in the past. The fact is, if contributing to a party or a candidate was in and of itself disqualifying, the most judges wouldn't be able to serve either, because the government could make the same thing on a judge who might have donated to Republican candidates. So though he's got to have a stronger case for disqualification showing actual bias than simply what's alleged at present. And I think it is, and it's oftentimes can be used as a judge shopping opportunity to try and switch the playing field, thinking that, well, this one's not working, maybe I can get the judge to recuse themselves. Most judges, they will oftentimes recognize the potential conflict or the appearance of a conflict before being notified. We've had a couple cases here in the First Circuit, high-profile cases of that sort, where judges have stepped aside because they saw the conflict before anyone ever had to raise it. And that's oftentimes the way that plays out. When you have to tell them, hey, you got to step aside, oftentimes then judges become on the defensive and then have to justify why they didn't do it previously. But again, I don't see that in this case. I think he's got sort of some generalized complaints. And again, with this litigant, and you and I have discussed this in the past, he always uses a scorched earth defense. There is nothing that he won't do to try and delay the day of reckoning or to escape justice completely. And so this is from the Trump playbook: is disqualify the judge, slow things down, try and defer things till after the election. And this judge wants to move this case forward and is going to move it forward on a faster track. And that doesn't serve his interests.
Okay. Before we get to the kind of blockbuster issue, yesterday was a pretty important day. The House passed that debt ceiling bill, and that's huge. And I just kind of want to congratulate McCarthy and Biden for working together like grown-ups and saving the day. And McCarthy in the face of blistering attacks from the nut cases in his extreme. And, Biden has to face some folks on his side who are also extreme. Pretty proud of them. And I have I have now some respect for Kevin McCarthy. So it seems like he's keeping his powder dry with the crazies until he really needed it. And he really needed it for this. And it worked out so far. And I'm confident it'll pass in the Senate, I hope. And I hope it does it quickly. Now, The other thing that happened today was a truly blockbuster piece of reporting on evidence that I guess first arose back in March, and that Special Prosecutor Jack Smith has had for quite a while, but we just found out about, is a tape, or maybe more than one tape, but at least a tape in which Donald Trump erases one of his defenses in the documents case, and that is that he thought that he thought that you could simply just think about declassifying something and make it declassified. As ridiculous as that is, if he genuinely thought that, and his lawyers could prove he genuinely thought that, in this really unfair world of rich people getting a break legally, they'd say, oh, and no intent. He didn't know. Of course, if I park somewhere and say, I didn't know I couldn't park there, doesn't matter. I've always been told that ignorance is no excuse for the law. I bring this up every time. If you're rich, it seems it is. Anyway, even though he is rich, he basically erased that defense by saying, if what we know about the tape is accurate, hey, yeah, I can't. I'd love to tell you about this planned attack on Iran, but I'm not able to. Blah blah blah. But can you kind of delve into the true importance in the pantheon of stuff involved in this case?
Yeah, sure. It's the question of, does the tape then show consciousness of guilt? If he knew that he couldn't just take the documents and do whatever the heck he wanted with them, doesn't that show a malevolent intent? And a lot of times that's what the juries want to know, is what was the intent, what was the motive behind what was going on, even though a lot of crimes, and I believe this is one of them, where it doesn't matter what your intent was. If you in fact had, and you're not supposed to have these classified documents, or shared them with others, you violated the statute. So I think what it does is it helps make that case more understandable to the jury, and an easier ability to find guilt beyond a reasonable doubt. But from a standpoint of how successful that defense might have been otherwise, it's somewhat speculative, no doubt. But I think most of us understand that we just can't will something to be. So I'm not so sure that would have been readily acceptable either. The problem is, when he's found on tape contradicting statements he's made before, it casts doubt on his credibility. And the argument always is to the jury, we saw it in the case with respect to his sexual assault case, is that if you can disbelieve some of what he said, you can disbelieve all of it. There's actually a jury instruction that says that. And so you've wounded, if not fatally, wounded your credibility. And that's always important when the jury starts to weigh through things like this. And on your other point, with respect to complimenting President Biden and the Speaker, I think most people agree with that sentiment. I think we're all sort of sick of all the bickering back and forth and the stalemate. The fact that they can get together and compromise and improve our lot, that's why we send them to Washington. And I'll bet most people agree with your sentiment that even if we don't like McCarthy, even if we don't like Biden, that congrats at least on working together sufficiently well that you've got something done that's important that had to be done.
I think this is a reminder of what it's supposed to be like, and I think it reframes the Freedom Caucus and the extremes on both sides as being counterproductive. We'll see.
I agree. Will it cost McCarthy his job, though? Because they can. The way the deal was struck before is that it doesn't take a lot of people to raise the issue of whether he should continue to be the Speaker. Right.
So good for him. If it does, then he's a hero. But he might have gained enough strength in the time, that he's had there to be able to withstand this. He kind of looks like, and both sides seem happy with it. Neither side got everything, but both sides at least say that they feel like it's kind of a win in general. maybe he is solid enough to withstand this. So back to the Trump tape. To me, and the whole Trump documents case, to me, this is now more about the will to execute the rule of law. And there is so much evidence, redundant, overlapping, documentary, witness, tapes to document. There's no question that he took documents and he kept them and he hid them. No question. And to the point where I would think maybe his defense would be seeking some sort of deal. And, there still is a question, did he show them to someone? Did he violate the Espionage Act? I'm guessing, if I had $1,000 to bet, I would go put it on yes, absolutely. Because he couldn't help himself. And
Right.
there's what's the word, hearsay evidence of this and that, and I don't know if they want to try to bother to prove that in court and risk a loss. But as far as the obstruction goes, at least, and we'll just say obstruction, it's overwhelming, not even a doubt. I'm surprised that people speak in terms of doubt. What are your thoughts on that?
Well, because you and I, this again goes back to conversations we've had. There's 30% of the country that are going to believe whatever he tells him, and there's another 30% at the other end that won't believe a single word that comes out of his mouth. This is why we're so polarized, and why we think it's such a great thing that McCarthy and Biden can actually come to the table and reach a compromise. So that shouldn't surprise us that there are some people who are never going to be convinced.
But this is about the law and not opinion.
Well, but this is the time period in which we're in now. It's not about facts. It's, in my opinion, constitutes a factual basis for what I want to do. Forget when you say, well, it's about the rule of law, which should be about evidence. Yeah, it should be. And you're absolutely right. It's about enforcing the rule of law equally. But the problem is that people now believe opinion constitutes evidence, and it doesn't. The question is, will that 30% on either end of the extreme here, will they actually look at the evidence once gathered and be able to objectively be able to make a call? I'm not sure, frankly, that that's the group that's going to.
So
it's the
why does
40% in the middle that you have to reach.
Why does that matter in the court? There's the Jack Smith and a trial, maybe. Are you talking the jury, if there's a jury?
Sure. The point, there will be a jury, because he'll want a jury, because as a criminal defendant, all I need is one person to agree with my proposition. And at the worst case, I get a mistrial and I live for another day. So there'll be a jury, no doubt about it. And just think, if there's 30% of the population on either end of this extreme, first of all, the group that would be the Biden supporters, they should be able to be disqualified from jury service for cause. So should the 30 on the other end. But there will be people who are in that pool who will deny their bias, deny their prejudice. Most people oftentimes do, because we don't want to see ourselves as biased or prejudiced. So there will be people on that jury that mirror our society, whether they be conspiratologists that will bite on any government looking into our lives too carefully theory, or that he's being railroaded because it's a political vendetta. The fact is, a criminal defendant only has to raise a reasonable doubt. And if he's able to do that by reaching some jurors, creating that doubt, then he's successful. The question I have, that you had, we've talked about this a million times, is fish or cut bait. Either bring the charges or move on, because it's hard to believe it takes this long to gather a compelling case when you've recounted some of the evidence, and we all know there's enough evidence that's out of the evidence that's out there. Either that's going to be enough that the prosecutor feels they can get a jury to bring back a guilty verdict beyond a reasonable doubt, or there isn't. I do not understand the delay here. I do not understand the delay in Georgia. It just makes no sense to me how our justice system in these cases moves so slowly, other than the point you raised about is the money and power influencing this process. And I think the answer to that question is no doubt.
Are people afraid, like physically afraid, or afraid for their jobs to bring charges? Sure, you could lose a case. You could lose any case. But if there's ever one you could win, it's the documents case.
Yeah,
It's a paper case in many ways.
If they're afraid, they shouldn't be in those positions. You know, the fact is, I was writing up some of the introduction for Minnesota Attorney General Keith Ellison today, and the fact is, if you're not courageous, if you're not willing to take on unpopular causes and really try to do justice and make sure that there's equal justice under the law, then you're not worthy of the position you hold. There will be times where you're challenged and where you will face the consequences of taking on unpopular causes. And for a significant segment of the population in this country, it will be an unpopular cause to try the former president of the United States on serious charges. But the fact is, I think, you think, that if we're going to honor the inscription on the Supreme Court of equal justice under law, then that needs to be done, likely in both Georgia and with respect to the documents case as well.
Yes. One related thing is that people say, well, you shouldn't bring these charges during an election. This person's a candidate. On the other hand, and that's political. But if you don't bring charges because they're in they're a candidate in a political race, that is also political. Either way, it's political. And so what? Yeah. Either you did the crime or you didn't.
Yeah, I
think you did.
I don't buy that logic at all. I mean, if there's evidence there that a public examination of it, either through pretrial or trial in the matter, will reveal to the voting public I think it's almost imperative that do move forward faster, so that we would have the ability to make a determination for ourselves whether that candidate is worthy of our vote or not. To delay it simply because of the election, to me, is counterproductive to the idea of an open and fair election and being able for the informed citizenry to make good decisions based on facts. I don't understand the delay. I don't understand the delay and the fact that you delayed and now you're afraid that it's going to interfere with the election. That doubles down on a stupid decision to begin with, if you ask me.
It seemed like Merrick Garland was treading water for so long before he got Jack Smith that he's the cause. I mean, I have no clue really, but that's how it appears to me. Jack Smith seems like he's really moved. You know, there's a lot of ground to cover, and that he's moved fairly quickly, but he got started a little late. I have one other question.
Sure.
Quick. We didn't talk about this, or we didn't discussing this. Is it Holmes? Is it Elizabeth Holmes?
Oh yeah. It's funny. I was looking at that last night. I was wondering if you wanted to touch base on that.
My only question is, what's that jail like? It's that's the Martha Stewart of jails. She went there. How bad is it? It seems like it would actually be kind of pleasant.
Yeah, well, I don't think any period of incarceration, no matter how short or no matter where it is a pleasant experience. So I'm gonna object to that. And I do think that is generally true. When your liberties are confined, regardless of what else may be available at that location, makes it for an unpleasant experience. With that said, the federal prisons are far nicer than some of our places to stay around here. But
this is a special federal prison. This isn't.
I don't know whether I would call it special. Because there's a lot of what you might call special federal prisons. We have Danbury down here in Connecticut, which by all accounts is quite nice as well. The federal prisons, as a general matter, seem to be operated to a better extent than the state without some of those overcrowding and other issues attendant to it. But also, one could look at it, well, they oftentimes tend to be white collar criminals and white, if you want to look at it that way. And so, is there an unequal justice system with respect to the shape of our prisons in this country as well? And my guess is those more informed on prisons than I would say, you bet there is. And the federal prisons are some evidence of that. So it's not such a bad experience as some, but it also, she's going to be there for the better part of 10 years while her children are little. It's still a pretty lousy existence, but that's what happens when you scam people out of millions and millions of dollars.
I guess it, as Phil Kate does suggest, I guess it depends on where you're coming from. If you're coming from a nice house in Connecticut or something, the jail might seem awful. If you're coming from some noisy, horrible, overcrowded apartment, maybe it seems nice. I heard it was a super nice place. Instead of cigarettes being a currency, quiche was a currency. And that, yes, you do have to get up at 6 a.m., but that they have swimming lessons and macrame and arts and crafts and GIMP lanyard making and all this kind of thing.
So it sounds like summer camp is what you're saying.
Well, yeah. So I'm super duper curious. If they offered a tour of that place, I might actually, on my own dime, go down to see. I'm that curious. Like, what is this place like? And talk to these people.
Well, you know, we've done tours here and TV shows with respect to the House of Correction here in Middleton. I'm sure I could discuss with Sheriff Coppinger if you can have some overnight experience, or at least a visit of an hour or so.
Yeah, but that's not the nice jail. That's not the Martha Stewart jail. I want to see the who else? Martha Stewart went there. Somebody else was incarcerated there, I guess.
But
I mean, Texas, it does seem kind of coincidental that they, these people go there. I guess it's part of a deal, right? They say, I mean, how does that work out? How do they get that nice prison? Is it part of a deal?
No. You're assigned, the Bureau of Prisons will assign you to where they believe it's an appropriate venue for your need for services and the like. What's surprising to me is that she's a great distance from her family where she's going to be incarcerated. And that obviously makes visits and those types of things that sometimes will make prison life a little more bearable, much more difficult. And so that's oftentimes a consideration, at least for family members, is am I going to be able to get there within a reasonable time at a reasonable expense? And she's going to be all the way in Texas. And I agree with Phil. He said he did a day-long tour in the New Hampshire prison system. These are serious places. And they're even having your liberty restricted for hours as opposed to days on end is a chilling experience, and that they're not comfortable places. It's
interesting to me that a few people get caught and punished. Like, did you say 10 years? I mean, that's significant. Even, Bernie Madoff, he got caught and punished. She got caught and punished. It just feels to me like there are so many others that don't. It's just my gut. It's interesting why a few rich people get caught and seriously punished. I mean, I guess it's good to see.
Yeah, it is. It is, and I don't disagree that again, there is an unequal justice here with respect to whether rich people are going to receive the benefit more often, even just on the basis that these financial crimes tend to not be prosecuted as often as they should be. And when they result in a conviction, Martha Stewart and Elizabeth Holmes, they do still seem to do better than most people would do in their prison assignments.
Yep. I just know that if I were to commit a crime, I would get caught instantly and get the worst punishment right away. And it irritates me no end when I see folks like the former president get away with stuff endlessly. Okay, I guess we're done here. This is this beef. It's the inequity there, and it's personal because I feel like I would get the worst instantly. Doesn't seem fair, and that's my beef. That is the theme through many of my legal talks. Is the heck with those guys. If I got caught, I'd be screwed.
Well, and frankly, your sentiment is what most people would experience. But we're not rich. We don't have a lot of power within the justice system, and unfortunately, those things still matter in our system, and that's why we still are working towards a better system of justice as we go. But I mean, the fact that Elizabeth Holmes is convicted and going to jail for 10 years, that's significantly different, as you pointed out, than most financial crimes we see.
All right. That's a good place to stop. That's 40
Okay.
minutes. Thank you so very much, Dean Coyne.
Thank you.
I'm glad we caught you at the end of the semester. You have your graduation tomorrow.
Yep, tomorrow night, 5:00. It'll be a good time.
Well, congratulations on another, what I imagined was probably a great year.
It was a great year. It was. We're very, very lucky. This is a terrific year.
And thanks for your time, and we'll talk to you pretty soon, I hope.
Goodbye, everyone.
Bye.